Alright everybody, last video of the evening, and this one will be on subpoenas. A subpoena is basically a legal document that is demanding or commanding information such as evidence or testimony in relation to a case of some sort. Most of the time, subpoenas are issued by an attorney, a lawyer, but it also can be given by the courts, in which you are required to attend a hearing and provide witness or witness testimony and evidence. So, a court order is a legal decision that demands something to be done or not done. So a subpoena can be a court order, which can only be, well, typically it's issued by a judge. Social workers like us are normally subpoenaed for cases such as divorce cases, custody disputes, visitation disputes, discrimination for employment or wrongful termination, those kind of things, depending on what field you work in, disability benefits. Those kind of cases are the cases that we are subpoenaed to be a part of. Criminal prosecution cases, those kind of things. But don't assume that because an attorney requests your client's records, that you have to give those up so easily. And that's what's very tricky about a subpoena. The only time you are really required to release records is if a court order signed by a judge accompanies the subpoena. If that's the kind of subpoena it is. I mean, our clients have the right to confidentiality. Very, very high bar that we cannot bring down or lower unless we are required to do so by a court order from a judge. So just because attorneys do have clout, but there are some ways around just so willingly giving information on our clients if it's just an attorney asking you to by way of subpoena. I'm going to read this. The NASW Code of Ethics, Section 1.07C, Privacy and Confidentiality, states, in all instances, social workers should disclose the least amount of confidential information necessary to achieve the desired purpose. Only information that is directly relevant to the purpose for which the disclosure is made should be revealed. So, if you do get a court order and the court order wants to know about your contact with a client who may have disclosed to you that they discipline their children, maybe the allegations against your client is that they physically abuse your children or their children, and you have in your client record that your client actually told you that they do discipline them, that they do use the belt, they may use timeout, whatever. You only have to disclose that information. So let's say that they tell you that the client actually tells you that one time before they left the bruise on the child. You kind of have to use discretion on what to disclose in your client's notes. You are giving the courts the information that the client has told you that they disciplined a child, but if it's just that one time where they used maybe a belt or something and left a bruise, You have to use your discretion about whether or not you choose to disclose the full record that has that information, because it could be used against the client, although it was just that one time and it was just something very minor, minor bruise from a belt. It wasn't a beating or anything like that. So, what you don't want to do is ignore a subpoena ever, even if it's not signed by a judge. If an attorney is requiring you to give information, don't just ignore it. You do want to respond. You may respond by telling them that you haven't spoken to the client yet. You have to get consent from the client. Just give them some kind of feedback and don't just ignore it. Let's see what else. You definitely, anytime you get a subpoena, want to notify your client, let them know what's going on, give them the opportunity to consent, and give them that choice of what they want to see happen. You do want to explain to them, though, that if it is a court order signed by a judge, that they may be limited in their own decision making at that point. But you do want to make sure that if you do have to give information, you want to go over the information that you are going to give. You want to document all of your conversations with the client, with any attorney, any clerk of the court, any kind of personnel dealing with the case. You want to document all of that. Some other things, if you get a subpoena, if you have professional liability insurance, notify the insurance company and let them know that you were subpoenaed, just so that they can have your back if possible. Of course, contact the client, let them know what's going on, and ask them if they are willing to provide a written authorization for the information to be released. Send a copy of the subpoena to the client and their attorney if they have one. If the client authorizes you to send it to the attorney, then you can. Review the information that's being requested. Let's see. Do not release the requested information without written authorization from the client or court order. And again, document all telephone calls, email, transactions, letters, consultations, everything, of course, we want to document and keep copies of. Let's see what else. I'm not going to go over all of this with you. Make sure your client understands what's going on, definitely, before anything else. You want to let them know that you got the subpoena, and you want to let them know what's going on, what to expect. Also, if the client refuses to give consent, the social worker may find it helpful to speak with the client's attorney. The client's attorney may be able to quash, not squash, but quash, which is the legal term, which means to block the subpoena. Remember, though, to always obtain written authorization to speak with the client's attorney. Sometimes we get comfortable with our clients and we only do verbal things because we feel comfortable with the client, they feel comfortable with us, but because we're social workers and we're professionals, we need to have written documentation that we can refer back to, because if you didn't write it down, it didn't happen in most cases, or at least that's the way, people in the field view it. Let's see. I mean, a lot of this stuff is just pretty much common knowledge, I would think. But you do want to make sure that you are familiar with subpoenas and what to do when you get one. Just a few last minute things before I end this video. It is important for social workers to understand the distinction between confidentiality and privileged communication. Confidentiality refers to the professional norm that information offered by or pertaining to clients will not be shared with third parties. Privilege refers to the disclosure of confidential information in court or during other legal proceedings. Let's see. So that's pretty much it. I don't want to keep beating a dead horse by telling you to record all of your client interactions and document what happened. But remember, though, that timing is crucial when responding to subpoenas, or you might run the risk of being held in contempt of court. So that's pretty much it in a nutshell. Please, if you have any questions, let me know. If I can be of any assistance to you, please check out my website, daytodaysocialwork.wix.com/my site. Please leave comments for me. You can like and subscribe and just share my channel with your colleagues. So until the next video, I'll see you later, and happy studying.